everybody. It's Georgia Reed, Managing Editor and your podcast host at Cybercrime Magazine. Today is October 1st, 2018, and I'm very excited to have Rebecca Hughes Parker here. She's the Global Editor-in-Chief for the Law Report at Accurus and an attorney. Specifically, your publication is the Cybersecurity Law Report. So welcome.
Thank you. I'm happy to be here.
Thanks. Us too. Rebecca, just tell me a little bit about yourself and how you got from, law school to now being the global editor-in-chief at a very niche publication.
So I started out being a lawyer, a litigator at a large firm for a bunch of years and did a whole range of cases, which was really fun, actually. And then I was recruited to start a publication called, actually, the Anti-Corruption Report. And after that was successful, we launched about in 2015, so 3.5 years ago, about the Cybersecurity Law Report. And basically, we are a bunch of lawyers, mostly who write it, with a few journalists as well. And we combine what we call sort of expertise journalism. We combine legal analysis and journalism to give guidance and color, basically, to what's happening in the legal and policy world of data privacy and data protection.
Okay, so this is a service that provides business analysis of critical legal issues that is specifically related to cybersecurity, data protection, data privacy challenges facing entities across what kind of industries?
Really, we hit a lot of different industries because it's clearly these are issues that are very universal. Some of our biggest sectors, probably the financial sector. They care a lot about this. The healthcare sector has a lot of risks. Retail, as we've seen, but really it's many different sectors. So mostly our subscribers are in-house counsel, chief privacy officers, chief information security officers at those companies, as well as outside counsel who advise those companies, and some other consultants and other people who are interested in these kind of operational issues.
And how often do you publish the report?
So we publish it every week, every Wednesday actually. It comes out online, and we distribute summaries of the report every week.
Okay, so I just want to pick your brain a little bit because our listeners, we have a lot of CISOs, hopefully some attorneys listening. What were some of your top headlines for cybersecurity as it relates to law for Q2 and Q3?
So I think we'll talk about it later, but I think the GDPR is obviously huge because it's a really massive sweeping law that came into effect on May 25th. So it's been discussed for about 2 years, but that was the implementation date for the law, which is an EU law, but does affect a lot of American companies. So there was a lot of interest in that in Q1 as well as Q2 as it began to be implemented. I would also say that some other laws that have been getting a lot of attention is the New York Department of Financial Services has a cybersecurity regulation, and it has a bunch of dates for certain measures to be taken. One of them was just a couple weeks ago. Another one is in March. So a lot of financial companies are very attuned to that, and they wonder what the NYDFS will do with that. And then there's just some more general operational issues that we hear about all the time: how to deal with a ransomware attack. Do you pay the ransom? Do you not pay the ransom? How lawyers in general can interact with technologists, how to prepare an incident response plan. I think the Equifax breach certainly brought that up. How are we prepared if there is a breach? Do we have a good cyber crisis communications plan? Certainly those are things. I'd also say that handling third parties who have your data was another very hot topic.
Okay, so speaking of third parties, you had something in last week's issue on September 26th about the Fiserv incident, and that was kind of a wake-up call. They were breached this summer. Fiserv is a third-party communications and cybersecurity. Well, tell me a little bit about what Fiserv does and what happened for financials.
Right, so it handles some data for financial entities, and because of the vulnerability that was discovered by someone else, a lot of the information that it had been handling was exposed. And that just serves as a reminder to a lot of these companies that handle this sensitive financial information that they have to be very careful with the third parties who handle it. And do they have the right provisions in place in their contracts? Maybe they want an indemnity provision? Do they have a notification provision in there so that the third parties have to notify them if there's an issue? It also brought up the idea of having perhaps a bug bounty program, which is when, as your listeners probably know, but which is when you have someone, a white hat hacker, research possible vulnerabilities like that so that you know about them and can fix them before a black hat hacker, I guess, can take advantage of them.
And we don't know who found the software vulnerability in the Fiserv.
I think it was just a researcher who told another journalist about it. So it was kind of a circuitous route, but I think a lot of our subscribers, especially in the financial services industry, are very interested in how they can best manage and vet and continue to monitor how their third parties are handling their information so that the liability doesn't come back onto them later.
Do you get a lot of confusion from the technology experts and the legal representation that they have about breach notification and when to report a breach and how that process is in place? Are there laws coming out about that?
Yes. So that's in the United States, that's often at the state level. So there's just about every state has its own law about when and how to notify them if there's a breach. So there's differing time periods as to when you discover the breach that you have to notify the people affected, the state attorney general, and sometimes the laws, as I said, aren't in harmony. So you have to sort of figure out a way to notify all the people consistent with these laws. The GDPR has its own breach notification. So if you're subject to that, you have EU customers, you have a 72-hour notification to the data protection authorities in the EU. So there's sort of a lot of things. If you have a HIPAA requirement or a Gramm-Leach-Bliley requirement, there's a lot of different laws in play there.
And I wanted to ask you about one other headline in last week's report, which is about the artificial intelligence in legal practice. So there were some potential ethical and liability pitfalls that you highlighted. Can you talk a little bit about that? Because AI is a really hot topic right now, and we're going to be seeing a lot more AI used both for cyber attacks and also cybersecurity.
Yeah, AI is definitely a hot topic, and there's people on either side. We're told by some it's dangerous, by some it's this amazing time and money saver. In legal practice, it's a little tricky. It can be helpful with the massive amounts of discovery lawyers have to do. So AI can help them streamline the documents they have to look at. But you have to be very careful on how you use AI and whether you're actually having it represent what you want it to represent. So we certainly have heard a lot on both sides of that issue.
So I wanted to talk to you about how technology people in the enterprises, the CISOs and the CIOs, how can they learn to speak the same language as the attorneys, and also vice versa? How can privacy attorneys communicate effectively with technology forensic experts?
Yeah, so that's definitely something we hear a lot, that lawyers have trouble. Lawyers who often aren't technologists have trouble working with technology experts and forensic investigators because in this field they need to a lot of the time. And some of the best practices would be certainly collaborating as soon as possible, because a lot of the trouble is that if you haven't collaborated early on and then there's a problem later, let's say you're designing some sort of product and you haven't collaborated together, and there's a problem later, you're now in much deeper trouble. Sometimes they're speaking different languages, the lawyers and the technologists. So a lot of words have legal meanings in these laws, like what's a breach, what's an incident. Sometimes
different definitions,
and technologists can make assumptions about what that means, and the lawyers have to be clear that they're on the same page with what those words mean. And sometimes technologists don't understandably don't want to slow down and listen to the lawyers. But it's important in many cases because, especially if there is an incident, you want a lawyer involved for privilege purposes so that a lot of this stuff can be attorney-client privileged.
I see.
So often you want a lawyer to hire the forensic investigator so that there can be privilege attached to that report. So there's certainly a lot of issues like that lawyers are thinking about, and sometimes technologists aren't. At the same time, there are things that technologists are thinking about that lawyers aren't, and lawyers need to understand. We're often told about how the business really works and what they're asking and whether it's reasonable in terms of the operations. Is it really, can lawyers make a solution that's compliant but also reasonable and doable for the business?
Okay, very interesting. We had something on our weekly rundown last week about the Facebook incident. And I wanted to kind of tie that into the GDPR. What is GDPR and what are the potential consequences of failing to comply? And maybe what happened with Facebook. I know that they have a lot of things going on in the EU. So
they do. So GDPR has actually kind of draconian penalties. I mean, it can be 4% of your annual revenue. So it's a lot. For Facebook, it's a lot of money. So the GDPR.
What were we talking about?
Like over $1 billion.
Wow. Okay.
In fact, they can. One of the first actions, as I said before, it was May 25th was the implementation date, so we haven't seen a lot of enforcement actions yet. But one of the first ones was against AIQ, which is a firm that handles political advertisements, and there's allegations that they misused data that came from the UK's ICO, which is the UK enforcer of the GDPR, and they have appealed the order, but if they don't win, they could face $20 million fine, which is a lot for.
Yeah.
So there can be possibly draconian penalties. They definitely built that into the law. Mm-hmm. But companies in Europe have been preparing for this for a long time. I think companies in the US are mostly aware of it, maybe not as much as they are in Europe.
Right.
But there's some broad territorial provisions in there. So if you are marketing anything to EU customers, or you think that you have their data in any way, you have to look at whether this GDPR applies to you and be very careful that you are complying with it. And one of those, as I mentioned before, one of those provisions is the 72-hour breach notification provision, so that you have to GDPR. So you have to tell them, as much as you know about the breach within 72 hours. And Facebook actually just had a breach last week, as you mentioned.
Right.
And so the Irish Data Protection Authority, which is one of the leading enforcers of the Act and has been at the forefront of talking about it and making people aware of it for quite some time, has just recently said that they are looking into this, and Facebook could face huge penalties for not having the right safeguards in place that allowed this breach to happen. So the head of the Irish Data Protection Authority is a woman we've interviewed in our publication, Helen Dixon, who's told us a lot about what she's looking for. And clearly she's going to be looking to make sure that companies are following the GDPR.
So Facebook could get into a little bit of trouble with the EU authorities if this doesn't pan out on what they're supposed to do. And another topic that our listeners are really interested in is insurance. When it comes to cybersecurity insurance, do you think organizations should have cyber insurance policies, and why or why not?
I mean, it's certainly a decision specific to your organization, your size, your risk tolerance. But I mean, in general, often the answer is yes, you should have some sort of policy that covers at least some of your risks if you're handling a lot of data. And these policies are changing as the market is changing and growing.
Okay.
There's first party coverage, which is for the breach, the actual immediate consequences of the breach. There's third party coverage, which is for a lot of the litigation consequences of the breach, like class actions, which is a big topic and something we write about a lot because that is certainly a collateral consequence of a breach that you can be sued in a class action. It can get very expensive. It can get very expensive. Just the lawyers themselves can be very expensive. And the standard is changing. It's not that clear as to what kind of injury you have to show to actually get through to a class action, to get through the standing barrier to actually bring the class action has been a hot topic among lawyers and companies and who can bring a class action. So those are things you have to think about when you get cyber insurance. What do you need to be protected against? And look at the market as it is now, because there's new products being introduced all the time.
Right.
And look at your current insurance policies to see if they cover some of this stuff. Your D&O policy might cover something. If it's a derivative suit, it's possible your CGL policy will cover some of it. So you have to kind of evaluate what you have.
Wow, thank you very much for touching on all of that. What can we expect in Q4 from Cybersecurity Law Report?
Well, we will. We have a lot of good stuff planned. We actually have a series coming starting on Wednesday about cyber insurance, as you brought up. So I have one of my great editors has interviewed a lot of people about this, and that's coming out Wednesday. It'll probably be more than one part, so we'll really do a deep dive into what to look for and the traps in the cyber insurance policies. There was a recent SEC action against Voya, which is a broker-dealer, for violating the safeguards rule, which is something the SEC has been doing here and there, saying they didn't safeguard their information. And, SEC enforcement is evolving. So it's really important for companies to understand what the SEC is doing if they're subject to them. We're always aware of what the FTC is doing, which is probably one of the major enforcers in the privacy area with Section 5 of the FTC Act. Mm-hmm. So, what are they doing? They put out guidance all the time. So we'll be following that. And of course, the GDPR Facebook case, we will analyze that as
Looking forward to it. Yeah. And where can our listeners subscribe to your report?
So we're at cslawreport.com.
Okay.
That's cslawreport.com. And you can take a trial to see our full access and, hopefully subscribe.
Excellent. Thank you so much. It's been really interesting.
Thank you.
Have a great day.
Thank you. You too.